Compromise of 1850. In U.S. history, a series of measures proposed by the Great Compromiser, Senator Henry Clay of Kentucky, and passed by the U.S. Congress in an effort to settle several outstanding slavery issues and to avert the threat of dissolution of the Union. The crisis arose from the request of the Territory of California, December 3, 1849, to be admitted to the Union with a constitution prohibiting slavery. The problem was complicated by the unresolved question of slavery's extension into other areas ceded by Mexico the preceding year. The issue of whether the territories would be slave or free came to a boil following the election of Zachary Taylor as president in 1848. In his first annual message to Congress, Taylor endorsed statehood for California and urged those exciting topics that had caused such apprehension to be left to the courts. He opposed any legislative plan that would address the problems that agitated Northerners and Southerners, thus preventing Henry Clay from pushing ahead with another compromise plan that, he hoped, would settle the issue for at least a generation, as had the Missouri Compromise of 1820. Then Taylor died just 16 months into his term, and his successor, Millard Fillmore, saw the wisdom of Clay's proposal and encouraged him to continue. Clay's purpose was to maintain a balance between free and slave states and to satisfy both pro-slavery and anti-slavery forces. The plan adopted by Congress had several parts. California was admitted as a free state, upsetting the equilibrium that had long prevailed in the Senate. The boundary of Texas was fixed along its current lines. Texas, in return for giving up land it claimed in the Southwest, had $10 million of its onerous debt assumed by the federal government. Areas ceded by Texas became the recognized territories of New Mexico and Utah, and in neither case was slavery mentioned, ostensibly leaving these territories to decide the slavery question on their own by the principle of popular sovereignty. The slave trade, but not slavery itself, was abolished in the District of Columbia, and finally, Congress passed a new and stronger Fugitive Slave Act, taking the matter of returning runaway slaves out of the control of states and making it a federal responsibility. With the influential support of Senator Daniel Webster and the concerted unifying efforts of Senator Stephen A. Douglas, the 5 compromise measures were enacted in September. These measures were accepted by moderates in all sections of the country, and the secession of the South was postponed for a decade. Indeed, the political system had seemed to work, and many Americans greeted the Compromise of 1850 with relief. President Fillmore called it a final settlement, and the South certainly had nothing to complain about. It had secured the type of fugitive slave law it had long demanded, and although California came in as a free state, it elected pro-slavery representatives. Moreover, New Mexico and Utah enacted slave codes, technically opening the territories to slavery. The compromise, however, contained the seeds of future discord. The precedent of popular sovereignty led to a demand for a similar provision for the Kansas Territory in 1854, causing bitterness and violence there. See Bleeding Kansas. Furthermore, the application of the new Fugitive Slave Act triggered such a strong reaction throughout the North that many moderate anti-slavery elements became determined opponents of any further extension of slavery into the territories. While the Compromise of 1850 succeeded as a temporary expedient, it also proved the failure of compromise as a permanent political solution when vital sectional interests were at stake. Fugitive Slave Acts. In U.S. history, statutes passed by Congress in 1793 and 1850 and repealed in 1864 that provided for the seizure and return of runaway slaves who escaped from one state into another or into a federal territory. The 1793 law enforced Article 4, Section 2, of the U.S. Constitution in authorizing any federal district judge or circuit court judge, or any state magistrate, to decide finally and without a jury trial the status of an alleged fugitive slave. The measure met with strong opposition in the northern states, some of which enacted personal liberty laws to hamper the execution of the federal law. These laws provided that fugitives who appealed an original decision against them were entitled to a jury trial. As early as 1810, individual dissatisfaction with the law of 1793 had taken the form of systematic assistance rendered to black slaves escaping from the South to New England or Canada, via the Underground Railroad. The demand from the South for more effective legislation resulted in enactment of a second Fugitive Slave Act in 1850. Under this law, fugitives could not testify on their own behalf, nor were they permitted a trial by jury. Heavy penalties were imposed upon federal marshals who refused to enforce the law or from whom a fugitive escaped, penalties were also imposed on individuals who helped slaves to escape. Finally, under the 1850 Act, special commissioners were to have concurrent jurisdiction with the U.S. courts in enforcing the law. The severity of the 1850 measure led to abuses and defeated its purpose. The number of abolitionists increased, the operations of the Underground Railroad became more efficient, and new personal liberty laws were enacted in many northern states. These state laws were among the grievances officially referred to by South Carolina in December 1860 as justification for its secession from the Union. Attempts to carry into effect the law of 1850 aroused much bitterness and probably had as much to do with inciting sectional hostility as did the controversy over slavery in the territories. For some time during the American Civil War, the Fugitive Slave Acts were considered to still hold in the case of blacks fleeing from masters in border states that were loyal to the Union government. It was not until June 28, 1864, that the acts were repealed. Missouri Compromise, 1820. In U.S. history, measures worked out between the North and the South and passed by the U.S. Congress allowed for admission of Missouri as the 24th state, 1821. It marked the beginning of the prolonged sectional conflict over the extension of slavery that led to the American Civil War. The territory of Missouri first applied for statehood in 1817, and by early 1819 Congress was considering enabling legislation that would authorize Missouri to frame a state constitution. When Rep. James Tallmadge of New York attempted to add an anti-slavery amendment to that legislation on February 13, 1819, however, there ensued an ugly and rancorous debate over slavery and the government's right to restrict slavery. The Tallmadge Amendment prohibited the further introduction of slaves into Missouri and provided for emancipation of those already there when they reached age 25. The amendment passed the House of Representatives, controlled by the more populous North, but failed in the Senate, which was equally divided between free and slave states. Congress adjourned without resolving the Missouri question. The following summer a considerable body of public opinion in the North was rallied in support of the Tallmadge proposal. Much of that anti-Missouri sentiment, as it was called, arose from a genuine conviction that slavery was morally wrong. Political expediency was mixed with moral convictions. Many of the leading anti-Missouri men had been active in the Federalist Party, which seemed to be in the process of disintegration. It was charged that they were seeking an issue on which to rebuild their party. The Federalist leadership of the anti-Missouri group caused some Northern Democrats to reconsider their support of the Tallmadge Amendment and to favor a compromise that would thwart efforts to revive the Federalist Party. When it reconvened in December 1819, Congress was faced with a request for statehood from Maine. At the time, there were 22 states, half of them free states and half of them slave states. The Senate passed a bill allowing Maine to enter the Union as a free state and Missouri to be admitted without restrictions on slavery. Senator Jesse B. Thomas of Illinois then added an amendment that allowed Missouri to become a slave state but banned slavery in the rest of the Louisiana Purchase north of latitude 36°30. Henry Clay then skillfully led the forces of compromise, engineering separate votes on the controversial measures. On March 3, 1820, the decisive votes in the House admitted Maine as a free state, Missouri as a slave state, and made free soil all western territories north of Missouri's southern border. When the Missouri Constitutional Convention empowered the state legislature to exclude free blacks and mulattoes, however, a new crisis was brought on. Enough Northern congressmen objected to the racial provision that Clay was called upon to formulate the Second Missouri Compromise. On March 2, 1821, Congress stipulated that Missouri could not gain admission to the Union until it agreed that the exclusionary clause would never be interpreted in such a way as to abridge the privileges and immunities of U.S. citizens. Missouri so agreed and became the 24th state on August 10, 1821. Maine had been admitted the previous year on March 15. Although slavery had been a divisive issue in the United States for decades, never before had sectional antagonism been so overt and threatening as it was in the Missouri crisis. Thomas Jefferson described the fear it evoked as, like a fire bell in the night. Although the compromise measures appeared to settle the slavery extension issue, John Quincy Adams noted in his diary, "Take it for granted that the present is a mere preamble, a title page to a great, tragic volume." Sectional conflict would grow to the point of civil war after the Missouri Compromise was repealed by the Kansas-Nebraska Act, 1854, and was declared unconstitutional in the Dred Scott decision of 1857.